travel is upon us as we approach the end of the year. And for those of us that got their green cards and were fortunate, well, this presentation is not for you, but for some of us that still await the green card or in the process of getting the green card, understanding the difference between the H-1B or the L visa status or the advanced parole if you have an adjustment of status pending is important. So this is a refresher if you've had studied this issue before, or this could be new for you. Traveling via advanced parole versus H-1B visa or L visa when we return. I am Sam Shihab.
I am Brian Burke.
And we are from the law firm of Sam Shihab and Associates. And we meet every Monday at 6 o'clock for an hour to discuss an immigration matter that's important to you and to answer your questions. And today we're going to be talking about traveling via advanced parole and H-1B visa or H-1B visa and the difference. Have you traveled since the pandemic, Brian?
Yeah, I've gotten a little bit of travel
overseas.
Overseas, I was in Mexico sometime over the summer.
Okay, so that's overseas.
Yeah.
Did you travel on H-1B or advanced parole?
I traveled. I traveled as an American citizen using my American passport, which I had to get renewed on a expedited basis because I'm a fundamentally conservative guy, and I know I would have gotten it if I didn't expedite it, but I paid the extra, whatever it is, $20, and just so I would have it very, very, very much early for my trip.
Okay, I did travel as well to Europe this year, and I haven't traveled throughout the pandemic. And oh my goodness, how crowded the airports are and the airlines are a mess. But we are in the travel season or approaching it. And if you are going through the green card process and have filed your adjustment status, you are probably have an advanced parole in hand, and you may have also an H-1B approval, or you are in H-1B status, either way. And we want to talk about the difference between the two. And I think a good way to start, Brian, is to talk about being on H-1B when you return, being on H-1B or being on a parole. What are the benefits and the of each?
Yeah, travel is kind of short, but ultimately all this good stuff that comes with it. So H-1B, and this is a scenario, where you have an H-1B and you also have a pending I-485. Mm-hmm. So the fundamental, benefit of maintaining your H-1B status while your I-485 is pending is that it gives you a backup. If something happens to your I-485 case, and I won't euphemize it anymore, if it gets denied, you have something to fall back upon. If your I-485 is denied and you're told, your adjustment is no longer pending, your EAD is dead, your advanced parole is dead, and you don't have anything to fall back on, you must leave the United States immediately. If you have an H-1B, a valid I-94, and USCIS has not touched that, great, you have the benefit of that, and you can stay and continue working, continue to fight a denial on the adjustment of status if that's what's happened, and it's just good. It's just good for you.
So we know that adjustment of status denial is a low percentage.
Yeah, we look at the USCIS adjustment data every now and again here, and it floats around like 1%, something like that. Pretty darn low.
Right. But I think 1% is enough to guard against. Now, we have dealt with the unfortunate adjustment status denial and appealed them, and we've had probably more luck than otherwise in overcoming these denials. A lot of them are government error. Some of them are, issues that need to be resolved. But government error can hit anybody. There's no distinction between.
That's very, very true. And I mean, I can count on my hands just 3 or 4 consultations in the last 5 or 6 months that I know of people who have gotten clearly wrongly denied I-485 cases that are just kind of left flummoxed. Yeah.
You get an officer, they're not in a good mood, they're not competent.
Yeah. one of my things I usually say is the local USCIS field office folks who are doing a lot of the work on employment-based adjustments right now, they don't usually deal with employment-based adjustments. They're historically in the service centers, and if they don't understand that, the portability rules, the INA, the Supplement J rules, for example, they could say, "What? You're not with the original employer? They withdrew your I-140? Well, I got to deny your case." And that's just one example we've actually, come across.
Yes.
So
yes, and the exchange usually between the officer during the interview is this weird one where you know that the officer is not focused, not informed, maybe sometimes not even stable, and then you deal with that. So, back on the topic, being on H-1B, and I know a lot of people, you hear attorneys say, why be on H-1B in advanced parole? And I think that's something that, in my opinion, oversimplification.
Yeah.
Yes, that recommendation is correct 98% of the time. It is 100% not correct 100% of the time. And we're here to advise you on what you should be doing.
What you should know about what the risks, what the benefits and what the risks are.
Yes.
Yeah.
So denial is a possibility. Being on H-1B clearly protects you from that. We're not saying you should be on H-1B. You should just understand that and make your own decision.
Yeah, that if you're not staying on H-1B, you might be giving something up. The benefits we discussed.
Now, if you get an H-1, let's say an adjustment, wrong adjustment denial, and you file a motion to reconsider, and the motion to reconsider is granted, now it doesn't mean that the case is granted. I mean the motion is granted.
Yeah.
Then what happens? You're appealing. Do you stay in the U.S.? What's happening to your status?
Well, if you don't have a valid H-1B I-94,
And you don't have a valid
I-94, and you don't have a pending adjustment of status, you're accruing unlawful presence in the United States.
Unless the adjustment.
I see what you're saying. Unless the motion to reconsider is successful and they approve the adjustment of status. So there's serious penalties that arise from accruing unlawful presence in the United States, attaching when you hit about 180 days, and even worse when you hit a year. And suddenly, if you don't have the means to stay in the United States to fight an erroneous adjustment denial, and they're taking a long time to address your motion to reconsider, you might be forced to, take a major risk staying in the United States in order to pursue it.
So let's get in the basics first.
Sure.
If the motion carries through and the case is reinstated, your stay in the U.S. is not unlawful because they will reestablish retroactively your status as of the date of the decision, your adjustment, and then you move forward.
Yeah. So if your adjustment's denied and you file and they say, "Oops, we made a mistake," you're good. You're perfect, right?
Yes. Now, but here's what happens. If you don't have an H-1B and you're denied in the U.S., you cannot even leave and re-enter to reestablish your H-1B because the moment you leave, it's an abandonment
of your adjustment
of your
status.
appeal.
Yeah.
Of your appeal.
Yeah.
So you really cannot leave the U.S. and get back on H-1B. You're stuck here. 1. 2, you cannot work to support the expense of an appeal because the attorney is going to say, well, it's going to cost some money to do an appeal. Where's that money going to come from if you're not working?
That's a great point.
Also, you're here to support a house, a wife, or a husband, children, and you're not working. How can, and there is an expense.
You have an entire life and lifestyle in the United States, and you're told by a random letter in the mail that you're toast, you have to leave all that behind immediately.
If you have an H-1B, the impact, it's upsetting, but the impact is not devastating. You have a job, you have an income, kids have status, you can afford the attorney, you can afford the life, and you can afford fighting it, and hopefully winning it and reestablishing it. So that's really with the understanding that the denial rates are low, not high, but it can happen to anybody.
Yeah, I mean, there's no guarantee that if you think you have that you can fight that I-45 denial, but at the very least, you have time to plan around it. If you have a couple years left on your H-1B, that's an eternity to, find it. Maybe it's a problem with an underlying I-140, find a new employer, get them to file a labor certification. Yeah. all these things. Yeah.
What is the drawback of being on H-1B?
Well, first of all, you are stuck with that employer's. Well, you work for your H-1B employer. So you work, generally speaking, most people work for one H-1B employer at a time. And for example, if you wanted to work for two employers at once, which is very popular right now as people are working from home, it's kind of a pain. Multiple dual employment H-1B filings is, just a pain.
Travel difficulties.
If you
want to get back on H-1B, yeah.
Yeah, I was talking to somebody, trying to get a visa stamping appointment in India, and this was just telling me today that, he got an appointment for April of next year. Brutal. It can be very, very hard to actually, get visa stamping to come back on an H-1B visa or any other type of non-immigrant work visa right now.
Very difficult,
Yeah.
yes. H-4 EAD processing remains impractical, not intelligent with these requirements, silly requirements.
Yeah. And, all of this kind of makes using that, makes a great segue because all of these problems make using that AP and EAD very tempting.
Very easy and tempting, and say, I'm taking the risk. What the heck? Well, it's fine.
You can take that risk, yeah.
As long as you understand what you're getting into, you make the decision. Obviously.
Yeah.
Okay, so advanced parole benefits.
Yeah, they are free. You throw out an I-131 application based upon your pending I-485. There's no filing fee. That's good, and that's great. Travel flexibility too. You don't have to go for stamping. You can wave to all those suckers in the line at the consulate and just use that advanced parole, come to the border, and they'll maybe take you to secondary inspection because they're a little bit paranoid about advanced paroles. But you'll get back in the United States that way. Great.
Is entry into the U.S. guaranteed for if you have an advanced parole?
No, sir. One of the very first things I learned as an immigration lawyer is, Brian, who's guaranteed entrance to the United States? U.S. citizens with their passport in hand.
You, as a U.S. citizen, are presumed
To be
immigrant.
Yeah.
That's U.S. law. Every person approaching U.S. land is presumed to be an immigrant unless proven otherwise. So they say state your citizenship, especially when you come from Canada. Those guys that take themselves seriously, they say state your citizenship. You say U.S. What evidence do you have? U.S. passport. Provide me your U.S. passport. Here it is. Okay, you overcome the presumption.
Welcome back. They get a bit nicer then, but yeah.
Yeah. So entry in the United States is not guaranteed with an advanced parole, although rarely do we hear problems.
Yeah, I'm sure everybody knows a friend who's had a horror story with, an H-1B stamping at a consulate, getting 221G'd, something like that. So, advanced parole, it's nice, it's good, it's it's an alternative to going through that rigmarole at the consulate.
So, what are the drawbacks of having an advanced parole?
Well, the drawbacks, there's no drawbacks of having an advanced parole, but when you enter the United States, using that advanced parole, you've left behind your H-1B status. You are, a parolee in a period of stay authorized by the Attorney General of the United States, right? And, it's kind of the inverse of the H-1B stuff. It's, you have the benefit of being here, but you have no layer of protection, You take away that H-1B, if something happens to that I-45, and again, it's low percentages of that happening, you have nothing to fall back upon. That's really...
That's the drawback.
Yeah.
Okay. So one of the drawbacks that is hardly discussed is as it relates to prior immigration violations. So we all know, and if you don't know, you should know, that there is a law called INA 245K, which forgives you if you have violated the terms and conditions of your status, worked without authorization, or you stayed out of status, beyond your status period, if you violated immigration law, in simple terms, for up to 180 days during
your visit to the United States. Yeah.
Stay in the U.S. Now, if you leave on H-1B and re-enter, you effectuate something in the law called new admission, an admission. And therefore, the clock resets on the 180 days. Any prior violations before your entry on your last entry on H-1B or L visa or F-1 visa, any prior violations are forgiven for the most part. If you enter the U.S. on advanced parole is not an admission. And people say, what the heck are you talking about? Well, admission is a legal term. Not entering it doesn't mean entering to the U.S. Advanced parole carries the prior violations from the prior state with it into the U.S. So let's assume you had, God forbid, 179 days of immigration work without authorization, H-1B gap, or employment, without proper documentation, etc. of 179 days. You travel on an H-1B and you come back again and you have 3 days of violations after that. You only have 3 days of violations. You enter the U.S. on advanced parole and you do a 3-day violations. That's 181 days, if I'm doing the math correctly, or 182 days of
Point
violations.
is, you haven't exceeded the 180
And that is a problem for your adjustment because you may not be able to adjust.
Yeah, and that's a realistic scenario. You realize you have a problem with a pending adjustment, and you say to yourself, "Okay, it's okay. I re-entered the United States." If you re-entered your H-1B pursuant to H-1B status, and you wipe the slate clean, and you can file a new adjustment of status. If you re-entered pursuant to an advanced parole, well, that new adjustment. Well, first of all, you can't file that new adjustment of status because you have to be, invalid H-1B status, and second of all, that advanced parole travel's not going to wipe the slate clean.
Yes. Now, the counting of the 180 days, I should highlight, it really triggers as of the day of the adjustment of status filing.
Yeah.
So you look back on that. Just a side note.
Yeah.
That may not mean a whole lot, but in practicality it can.
Yeah.
So a lot of people say, listen, I can make so much money working for an employer without an H-1B. There's a lot of companies don't want to apply for H-1Bs.
Yep.
I need that flexibility.
Sure.
My wife is working. She's out of H-4. And man, this is a headache for me.
Well, sir, I've explained to you the benefits of maintaining your H-1B status, but there's benefits of being on that advanced parole. That's a personal decision for you. The decision is different for everybody. It's kind of a risk-reward scenario. You make that choice. I feel good as an attorney having told you, what the benefits are on each side.
So with that fact, 95% advanced parole is frees you from all these restrictions. But there's that percentage that I have had those calls, maybe because we are in this business as attorneys, we see these things. Those guys calling and say, I can't believe what happened to the interview. I cannot believe how I was treated. I cannot believe she denied me. And the first question say, well, are you on H-1B? And they would say yes, and they go, what a relief.
Yeah.
We can deal with this.
I mean, for it's also dependent upon personality. I can imagine two people with, the exact same factual background, but it's a matter of your level of comfort, your level of, desired risk. Just because you have a good case doesn't mean, you feel comfortable. It's kind of personal in your head as well.
So having both, what do you think?
That's good, So you keep on until that green card's in your hand.
So how can you have both? You have to enter on an H-1B.
Always enter on an H-1B. If you're in the U.S. already, you're excited. You get that EAD and AP in the mail. You go, yay! You give yourself a high five, and then you put them in the filing cabinet in case you need them.
And you could enter on an advanced parole and join your H-1B employer, and there is a memo that's decades old that says, you can join your H-1B employer, and this H-1B employer can get you back on H-1B.
Yeah, I want to reiterate this though. So about almost 20 years ago at this point, I think it is, USCIS has this policy that says, okay, we understand that once we give you have your H-1B status, and once you have this advanced parole, you're going to want to use it. So what you can do if you leave the United States while you're in valid H-1B status, and then you come back, returning to the exact same employer on your advanced parole, we're still going to honor your H-1B. We're going to be nice to you. We're going to allow you to file to extend your H-1B status when you come back, and that's kind of it.
Well, the moment you join the employer, are you back on H-1B automatically?
No. You're still considered a parolee, but basically when they approve that H-1B case, that extension case, they'll basically extinguish the parole and make you
Only
a
on an
non-immigrant.
extension.
Only on an extension.
Okay.
But so the challenge there is your employer has to be willing to do that for you. But you're a valuable resource to your employer. You've been with them for a long time probably, and you just say, I prefer to be on H-1B status, and you can do that. And obviously there's 1,001 reasons why you might be able to file an amendment or extension at any time. So it is possible to really, come back to the United States on advanced parole and just in a matter of days get a new H-1B out the door and get approved to give you that benefit.
Yes.
Yeah.
So that's really the difference between the two. And we are going to come back in a couple minutes to answer all your questions. And we wanted to give you a brief presentation today because I know a lot of you have questions and we want to get to all of them hopefully today when we come back. Right, so we are excited to answer questions, and I see some questions lined up here already. One thing to remember, we will answer your questions to the best of our ability, but that's not a substitute of legal counsel. We are here having discussions and chats to help you, guide you, give you general information, but obviously before you make any decision, consult with a competent lawyer that can give you good advice as to the specifics of your case to be able to help you out. Without further delay, let's jump on the first question.
Let's see what we got, yeah. There we go, from Senthil Kumar. I learned that my case got transferred to my local field office on the 8th of this month. Could it be for EAD or GC consideration or something else? So, EAD, that's not going to be approved in a local field office from anything we've seen.
At least it will not be, will not transfer for an EAD.
Yeah, so generally speaking, I'm going to presume that your case is going to a local field office for the purposes of being, adjudicated by a local officer. If your priority date is still going to be current in October, or it's still reasonably close to current, I would expect that sooner or later somebody's going to once your priority date's current, somebody should be able to make a decision on your case. Yeah. So generally speaking, for people that aren't aware, if your case ends up in a local field office, it tends to mean that USCIS is working on approving it.
Yes.
Gonna keep on going here.
Siva?
Yeah.
Priority date January 2014. Do you think I might get visa from 60 years spillover 2023, and when? I personally think you should, in my opinion. I think we should get beyond the retrogress date before the end of the year, hopefully by mid-year. And by when?
I think we should make it back to December 2014 by the end of this upcoming fiscal year. Yeah. Because,
correct.
The bottom line...
But when can he get a green card?
Before sometime...
And that's the $50,000 question. They got to adjudicate those cases and get them out before the end of the fiscal year.
Based upon Siva's date, I would guess, Q3 of this upcoming fiscal year. So that would be what?
July?
Yeah, June, I think. I'm not gonna the Q3 of this fiscal year. So sometime during calendar year 2023 is when it
October.
Seems
back it up 3 months.
Yeah, there you go.
All right.
Yeah.
All right. Silver. Gem.
Silver Gem. I like that name. So I got my EAD and AP approval today.
Whoa, nice.
However, my employer suggested that I should use H-1B instead of EAD. They told me they can use EAD as backup later. Did this employer get preview of our presentation?
Yeah. Did we send Silver Gem to ask that question?
Yeah, I know. It sounds like a plan, but different strokes for different folks. But that's a good conservative answer if they're worried about something. If they're just want to make sure they can keep you on H-1B.
I think that's a good thing for you to stay on H-1B in my opinion. Absolutely.
H-1B's been good to people. It's kept you in status for a decade. Let's trust it to the very end.
Exactly. Ajay Shah. If I travel to India, when I return back on advanced parole, will my work status change to EAD automatically, or am I still on H-1B? So when you return, you are on advanced parole, and by the operation of the law, you are on EAD unless you join the prior employer, your current employer, and if you had an H-1B before, you could be considered to continue to work on H-1B. And the reason being, Brian, he could, because that memo that's 22 years old was talking in the context of not having an EAD altogether.
Yeah.
And it said that you can enter on advanced parole even if you have your EAD. You can join your prior H-1B and
pursuant to the H-1B work authorization. Yeah.
and begin. And therefore, I think they're technically back on H-1B the moment they start working for the employer. So, and that's something we can probably debate as lawyers. But for the purpose of answering that question, I think we've given.
They will honor your H-1B work authorization. If you file an H-1B extension, they will approve, your H-1B extension.
And if you don't have an EAD altogether, you're allowed to join the employer.
You must rejoin your current.
In which
employer.
case you're definitely on H-1B. That's the only status you're on. That's what I'm highlighting. Yeah. You're shaking your head.
I don't know if you're on. I know they would consider your work authorized. I would debate whether they would consider you on H-1B status, but I agree they would consider your work authorized.
This administration will.
Yeah.
I understand. A conservative administration might not. Yeah. This administration will because we've had situations where somebody joined for a short period of time and they moved on and transferred.
I would say that any time that old 22-year memo comes up, I would say, don't put too much weight on it. Yeah, rest upon laws and regulations, not memos from 22 years ago. Yeah.
Blacks me too.
Yeah, blacks me too. So, do we need to carry green card always? Someone told me it's a misdemeanor. If not, is it true?
I don't know the answer to that question, but that's a great question. You know what? I'm going to look it up. I don't have an answer. I don't think it's a misdemeanor not to carry a green card. That's absurd.
I know, Sam, I have one of those U.S. passport cards, right? And sometimes when I'm traveling, internationally, I'll keep that with me just if I don't have my passport. I don't blame people for not wanting to do that because it's an important card, and we're all human, and you don't want to lose it. So
I don't have an answer whether it's a criminal violation not to carry your green card with you, but it makes me nervous having to carry. If you lose it, it's a pain in the butt.
Yeah, big time.
I'll look it up and we'll post it. How about that?
That's fine.
Can we do multiple jobs parallel with green card? Absolutely.
Yeah.
You can do self-employment, no employment.
Yeah,
three jobs.
When you're a green card holder, you're a green card holder. Live wherever you want, work for whomever you want, work for one employer, work for 10 employers. And, I will mention, it's in our email signatures, you are still required to update USCIS as to your address within 10 days of moving on Form AR11. Go to the USCIS website and do it, folks.
But not when you change jobs. They don't care about that.
Yeah, they don't care. You work for whoever you want. You're free.
Akshith. Hi, I have interfiled from EB3 to EB2. My 45J approved and 45 still pending. Can I use my EAD for a new job and advanced parole for traveling? Please advice.
Oh, so that's interfile from EB3 to EB2. Yeah, those, think of it this way. Consider that EAD and AP attached to your adjustment of status. You still have the same adjustment of status.
So the answer is yes.
Yeah, short answer.
Yeah, the answer is yes. You can absolutely use that.
Yeah.
100%. Ajay Shah. Can I work 2 jobs on EAD? Yes. Can both be 2 full-time 40-hour jobs? Yes. Or 1 full-time and 1 contracting job, self-employed? Yes.
Yeah. Basically, as we said, we talked about green cards a moment ago, but, pending green card EADs, they are unlimited. You can work for one of their benefits is you work for as many employers so you want whatever hours that you want. However, you still must always have, until your green card is approved, you must have an offer of permanent employment in the United States. You have to have somebody willing to hire you on a permanent basis upon getting that green card.
Yes. Brian, take that one.
From Tegan Thomas, is there any hope for 2016 priority date anytime in the near future?
That's a tough question, my friend.
I think it's difficult to say in this fiscal year because it's the furthest we've made it on actual final action dates was December 2014, and there's an entire year of 2015 priority dates in there. I am slowly working my way towards some help on trying to get a good idea of what that number of 2015 priority date green cards there are, but It's 2016. Let's hope. Here's the things to hope for: reform, an interesting event that causes the dates to move forward, or some sort of presidential action that changes the counting of the numbers.
Yep. Vera S. My priority date is June 2012. I have my old employer applied my green card finally on September 8th. Any chance of January 2012 getting current in 2023?
I think it's June 2012, the priority. Okay. So, yeah,
we think so, absolutely.
I mean, we're what, in my visa bulletin copy is over here. We're, what is it, April 2012?
April 2012,
yeah.
And he wants 3 months movement only. April 2012 for both EB2 and EB3.
Yep.
I see, absolutely, yes.
Yeah, it is. I mean, we expect the EB2 final action date to, as they release visas across each quarter, we expect the final action date for EB2 to move forward.
Yes.
Yeah.
All right.
Arinda Malakar. My priority date is June 5th, 2015, EB2. Child is exactly 17 now. She will step into college next year. When do you apply? When do you advise I should apply F1 COS for her? Now, or should I wait some time? Please advise. So.
Okay. So obviously, what the law is. Let's start with the law. The law is that she can be dependent on you until 21.
Yeah.
And then it looks like you have an EB2 priority date. I don't know whether 2015. So you never filed for an adjustment. Looks like.
Haven't
filed for an adjustment. So the question for you is, what is more advantageous, to do an keep her on an H4 or file for an F1? And I think an F1 is, honestly, I wouldn't jump on F1 because there's a minimum coursework you have to do. Minimum.
Yeah, there's financial requirements that must be met. There's fees that must be paid.
And minimum number of courses that she must take. So a bunch of restrictions you don't need to do. I would wait until at the last minute.
You should acknowledge that it does take a long time to approve a change of status to F1, but 4 years out is probably a bit premature.
Yes, I would wait maybe until she turns 20.
Yeah, that's when you really got to start thinking about it for sure.
I agree. All right, so from I cannot see that. Is it
KJ Havar? I'm going to say.
Okay. My priority date is February 2012 EB3. Okay, so April, February, March. Okay, so it's current.
Yeah, it becomes current in October.
And has become current in October. Would appreciate your take on how much time USCIS will take to process and issue green card. So, first of all, I would assume that you have an adjustment of status already pending.
Yeah.
From prior filings, from prior movement of the priority date, and I'm assuming it's 2 years old or adjustment. So this case is ripe for movement. No delays, no issues.
Yeah. I mean, counterpoint, Sam, we've dealt with people who filed in October 2020, were current for months and months and months, and USCIS started to get through them. It's a little bit, it is very possible for them to get cases very quick. It is very possible for them to get cases very slowly.
I just do not, but India EB3 is suspect for backward movement because I just don't understand how it moved forward.
Yeah, they have so many cases in their queue, in their hands right now, and just not that much EB3 visa availability in a given year.
Yeah, so I don't know. Not everybody's going to get it. I'm sorry to say this, going to be negative a little bit about the EB3. But I hope your case is one of those picked up for a forward movement, but it's hard to answer that question, to be honest with you. Silver Jim again, are they going to start processing new employment-based green cards for the rest of the world on October 1st? Yes.
Yep.
So that's the whole idea, right? The rest of the world, hopefully...
those guys have theirs available, but they're not going to take that many of them. And basically, once that quarter's done, they'll say, I guess the rest of the world didn't really want that many, and that's when they'll start pouring into, moving into other categories. Yes.
Rajini Gupta.
Oh.
I am at India, have an H-1B stamp, okay, but my employer is not giving me I-797. Can I use the H-1B stamp and move to another employer? Do I need to get new I-797? So you're in India, the employer does not want to have you come back. And the question is, can you transfer? Can you find another employer? Yes. The answer to that is yes. You really don't need the I-797.
Well, I'm imagining somebody who's never been on H-1B status in the United States before, and I'm imagining, well, you probably need something for that H-1B filing to avoid USCIS getting confused. Do a FOIA.
Well, so are you assuming that Mr. Gupta never came to the U.S.?
Yeah, and that's kind of what I'm imagining. Basically,
Okay, so it's an October.
Yeah, maybe in October from last year.
Cap case, maybe.
I got a cap approved. I went to the consulate to get a stamp, and they said, "We're not ready for you yet." And I know what that's. I've been counting against the cap. I have other opportunities. Can I find a way to get to the United States through somebody else?
So you can do something called FOIA, which is Freedom of Information Act request, and discover your entire file, a copy of your entire file, including the approval.
Yeah.
So that can be done reasonably quickly, a few months to get it. You can also file for transfer once you file a new employer, and you can reference an approval that the employer is not giving you, and a lot of time USCIS will
they're pretty nice about that.
We'll look it up
So
for you.
it's a
Yeah,
good thing,
so that's another possibility as well. All right, so moving on to
okay.
Sharma, Rohit Sharma, 1601.
Yes. Priority date 11/13/2022. That can't be right. It's got to be 2012. AOS pending with I-140 approved and medical RFEs medical filed with AOS application. Any chance of it get adjudicated as part of fiscal year 2022 pending applications. So basically what I'm hearing here is a scenario where I am current per the visa bulletin for the month of September, but I'm not going to be current in the month of October because the dates have retrogressed. You know, USCIS says that they used up all their green cards for the fiscal year sometime around September 6th, I believe it was.
We've seen some approvals.
Exactly. You know, I've talked to people on the phone and they said, Brian, you know, I know that's what they said, but I have friends who are getting I-45 approvals. So it's possible. It kind of runs contrary to what we know and what we've seen in USCIS officers going to a computer system to allocate those visas, but they work in mysterious ways, and I don't deny the fact that people are getting approvals, you know?
Yeah, absolutely.
So I'll cross my fingers for you.
Yeah. Rajesh N. I came back on advanced parole, did not use EAD. I have an H-1B, H-4 extension pending. My wife is in India. She has advanced parole. If she gets H-4 stamp, can she come back on H-4 instead of advanced parole? Thank you. Excellent question.
Yeah.
That's an excellent question. I'm assuming you have joined your prior H-1B employer. And that's where you and I were discussing the debate on whether or not that person is in fact on H-1B or not.
Without a 994, Sam, I'm going to say there's a legitimate question as to whether or not she's, you know, on H-1B. And so basically, and that goes down if the spouse is on, how's she going to get H-4 stamping, Sam, without a valid approval notice from this guy?
If she gets H-4 stamp.
Yeah, how's she going to get H-4 stamping without a valid H-1B approval notice from her husband?
Well, she has an I-797 approval notice. She can present that.
Well, she doesn't have it yet. His H-1 extension is pending.
Portability. You can get an H-4 under portability of the H-1B. It is possible. So let's not get bogged down with that. Can she come back on an H-4 instead of advanced parole? Thank you so much. So it's possible. You have to be very careful. I think there's a lot of details that we need to go through to make sure that you've joined your prior employer. And with the understanding this memo that we would be relying on is 22 years old.
My conservative answer, as the clear-cut answer, is once your H-1B is approved, she's entitled for she's assuming that you're not in status right now. Once your H-1B is approved, you have an H-1B I-94. She's definitely entitled to get stamping, H-4 stamping, and come to the United States on H-4. Do you agree?
Your answer is right on, and I would upgrade to premium processing to avoid any confusion. My philosophy in immigration law is never get somebody caught in a gray debatable area. And this is an area in which good debate can occur. Yeah. And we as lawyers love to debate, but you as consumer of the visa
I would love to write that appeal, Sam, but I don't think anybody wants to have that appeal written for them.
Exactly. So I would definitely be conservative and make sure that your H-1B is approved before she jump on the H-4 for her and your peace of mind. Ajay Shah.
So my EAD/AP was approved when my EB3 I-45 was pending. Then I traveled out of the country on AP. Does this mean I am tied to EB3? I have now interfiled to EB2. So is EAD/AP tied to EB2, EB3 category?
Excellent question.
Yeah.
So the advanced parole is a benefit of the adjustment of status. It hangs on the adjustment of status application. It's an incident to it. And if you told the government that you're moving your adjustment of status from an EB3 to an EB2 or from an EB2 to an EB3, everything else moves with it. Mm-hmm. So you're just fine. The advanced parole follows the adjustment wherever the adjustment goes. Yeah. So you are now, if you're interfiled, then that advanced parole and EAD is in the EB2 column.
So let's see what we got from Coach Ron. So hello to both of you. Also, counting family members also misinterpreted. Can this be fixed too? Is it bad policy or misinterpretation? Nowhere is it mentioned in the law/bill to count family members.
Don't get us started, Ron. We think the whole thing is ridiculous. Absolutely. Counting family members against the cap is something that the administration can do as a matter of policy. Nobody has the you-know-what to get it done. Unfortunately, they talk the talk, but they don't walk the walk. Unfortunately.
Yeah, I mean, in theory, you can lobby, your congressperson to do these things, but they haven't done it yet, and we believe that there is kind of, is largely bipartisan support to fix these issues.
Just decouple them. Yeah, just decouple them. Especially for the waste, at least to counter the waste.
Yeah, the waste is infuriating. The 60,000 rollover from this year to this year is infuriating in light of the 60,000 waste from the last year.
Yes. So is that CBA again?
Yes, I think we are.
Can a person work on green card EAD and H-1B from concurrent filing simultaneously? If so, what will be the status? So, Brian.
I love metaphors, you know this, Sam, and I consider your green card EAD and H-1B status to be oil and water. They don't mix.
Yeah. So the answer is no. Yeah. The straightforward answer is no. I know for a fact that there are pundits out there on YouTube that they think that they're not lawyers, because I don't think lawyers would ever make that mistake, that say, oh yeah, you can do both, and I'm like confused. No, you cannot be on both statuses. You cannot be in H-1B and not in H-1B at the same time. You cannot have a hat on and not have a hat on at the same time. You either have a hat on or you don't have a hat on.
Your metaphor is much more confusing than my oil and water one. I love it.
Dual citizenship, another thing people confuse. If you are a citizen of, let's assume, 2 countries, the passport you present, you are a citizen of that country for the U.S. You're not a citizen of 2 countries for the U.S. You leave, if you're a citizen of India and Pakistan, let's assume. You have 2 passports. Unlikely, but that's an example. You enter the United States with a Pakistani passport, you're a Pakistani citizen here. You'll be treated under the treaties and the laws of these countries dealing with each other. You enter with the other passport, that's how you deal. Same thing, H-1B or not H-1B. You cannot have both. Laughing, Brian.
I like your hat metaphor. So I think maybe no. This is a new one from Rohit Sharma, 1601. Priority date 11/13/12. AOS pending with I-140 approved and medical files with AOS application. Any chance of it getting adjudicated as part of the fiscal year 2022 applications? I think that maybe that's the one I answered there, and I think maybe who knows? Yes. Yeah. Silver Gem, H-1B stamp is always safer.
So Silver Gem is giving us an opinion.
Yeah.
And we agree that H-1B stamp, if you can get it, is always safer than advanced parole if you can get it. Absolutely. And we encourage people. And we know, Brian and I, we were talking about this. There's a lot of advocation out there that, it's silly till you get both of them. It's ridiculous that you do that. You're making the lawyer charge you more money. And I shake my head because it's like, most of the people that going through the green card process between the age of 35 to 45, especially from India. That's the age group. Mature professional who have invested heavily into this country.
You got a house, you got a car, you got
children.
Yeah, U.S. citizen kids most likely.
Yeah.
Yeah.
And all of a sudden somebody's telling you, save $400, okay, and take 4% extra risk. I don't get it. All right. Ajay Shah, if you have EAD approved and I'm currently on H-1B, what is the best way to move within same company from H-1B to EAD? So if you want to get off your H-1B to employment authorization document, it's the intent.
Yeah.
It's your intent. And the only way to do it is to complete an update new I-9 form, and you can probably write an email that says, I'd like to begin using my employment authorization document as evidence of my stay. Please update my record. I no longer wish. And you know what happens is, for example, if somebody wants to work in an area that's outside the H-1B area.
Yeah.
So they want to move. Yeah, they want to move, and they just don't want to file an amendment or wait for that.
Yeah. I mean, as an aside, it's not like that I-9 form, goes to get sent to USCIS. It actually gets, kept in the employer's files. But you said it's about intent. It's about what you want to do. You can use whatever one you want, and just by manifesting that intent by saying, hey, please change me over. That's enough.
Yes. You got the next one here, Brian.
So from Aryan K, hello. I traveled and came back on EB3 AP. My EB2 AP was pending when I was traveling out of the U.S. Can it get denied? Also, do we have to be in the U.S. to apply for AP? Thanks. So, USCIS has a policy of denying your first advance parole.
If you're outside the U.S.
If you're, they approve some first advance paroles if you travel outside the United States while your first AP is pending. There you go. In this scenario, a second advance parole while your EB3 AP is valid. I'm not sure how they'll interpret that.
Is it filed when the prior one is valid, and is the other one? And you're outside the United States pursuant to the first one? I think if you file that concurrently, before it expires, you should not have a problem.
Likely yes, but I wouldn't. You wouldn't blow my mind open if you got a denial notice on that. And
do you have to be in the United States to apply for advanced parole? Yes, you do. Alok, any prediction for EB3 date movement in fiscal year 2023? Well, our prediction is more conservative than the government.
Yeah.
We are confused as to how they moved it forward because.
What was it, Sam? They had in their hands at the end of this fiscal year. USCIS has 27,000, I think it was EB3 adjustments in their hands. Where they also say, for this year they had an allocation of 12,000. So assuming you have the same allocation next year, you have enough visas to make it through half that backlog, and thereby we're sort of perplexed as to how EB3 can move much, let alone, we were surprised that it moved at all in this visa bulletin.
We think this year's allocation should be somewhere between 8,000 to 16,000 is in that range. I just look, I put a 2 multiplier here, 8,000 to 16,000 in that range, and it's just too many EB3s.
Yeah.
Unless they're thinking, like you said, the EB3s.
Duplicates will move to EB2 category, something like that. Yeah.
Yes, absolutely.
Maybe they know something we don't. Certainly, there's a good chance
I'm sure they do.
Yeah.
All right, Ranjan Madhav. I applied for my H-1B extension and then traveled and came back on advanced parole to the same employer. Okay, my H-1B extension is still pending. Do I have to do anything for this pending extension? Thanks. No, you just have to wait for it to be approved. So looks like you were on H-1B, you entered on advanced parole, you joined your employer again, and then there's a pending H-1B extension, so that extension will be approved, and then he will continue to be on H-1B.
Yeah, I agree with that. I think it's sometimes that scenario can be confusing to people, but that's what they should abide by. They approve that I-94. You don't abandon your extension request by traveling outside the United States. You're here, they approve your H-1B, Yeah, they should.
And the point I think we should highlight is that the memo that is 22 years old now is just a memorandum. And it is not regulations. It is not the law. It is not in the in the policy manual of USCIS. It's just a memorandum that was written 22 years ago by what used to be called INS at that time.
Yeah, I think it's,
and still used today, and we see evidence time and time again that USCIS is honoring it, but it makes us nervous because there's not being a renewal. It would be nice for them to release an updated memo
or
that
do what
says,
they should do and codify it some way.
throw it in the code, throw it in the policy.
Yeah, policy handbook would
Handbook
be good.
would be wonderful. So we rely on this memo that's really old, but we see it working all the
Yeah, I
time.
tell people, in that scenario, there's odds are they're going to approve your H-1B extension, but don't consider it a guarantee.
Yes. But we do see it time and time again. We do see it being honored. Harsha. Since there is a lot of demand for rest of the world based on last 3 years average, how confident are you about the dates moving into 2013 with 60K spillover? Well,
which date's moving into 2013? I guess because that's EB2 or EB3. EB3, we're not optimistic, right?
yeah.
To answer that initially.
Yeah, for thanks for the clarification. Yeah, we don't think EB3 is going to move much because even with the 60,000 spillover, we don't understand how, when we run the numbers, and we don't think there is a lot of demand from rest of the world. I just don't see that because 2022 numbers were high for the rest of the world on the I-140 approvals. But remember, rest of the world files concurrently.
Yeah.
And because they file concurrently, because USCIS moved the allocation in the fourth quarter for India EB2 last year from 51,000 to 60,000, okay?
Yeah.
It means that they ran out of the rest of the world to approve.
Yeah.
There were, obviously there's some...
Yeah, let me explain that a bit. So in the beginning of August, I believe it was, late July, in a court case, USCIS published that, hey, we think that there's going to be about 51,000 EB2 India visas available. Then a month later, in September 6th, they said, oh, it turns out, our estimate's more like 60,000 EB2 India visas being available. And basically, those numbers, the 51,000 came with an asterisk and the 60,000 came with an asterisk, and it's basically because those numbers, when the rest of the world doesn't use visas, they become available in India.
Fall across. That's called fall across. Yeah. So that means they couldn't approve anymore the rest of the world. Yeah. They couldn't crunch more the rest of the world. They just didn't have the bandwidth from the rest of the world to approve more green cards. So going into this year now, 2022 I-140 approvals has dropped by about 30%, at least looking at the first 2 quarters numbers and comparing it to prior years. So there is a dive in I-140 approval.
I can't help but wonder if the slow perm processing times are really slowing down, putting a delay into the I-140s. But
whatever it is,
it is.
There is. It appears to me there is a slowing of the rest of the world, and by the fact that everything has been current for such a long time, a whole year, year and a half of it. 2 years, as a matter of fact.
They had a massive visa availability last year, and they approved all the rest of the world people. So
we think rest of the world is not going to be a lot of demand. I think we hope to be a decreased demand of the rest of the world, which India EB2 will benefit from.
Yeah.
And that's our theory. Now, how confident I am? We just basically predict and hope for the best.
We take in our data, we see what the visa bulletin's done, we look at all the data from all the various sources and try to model it as best we can.
We're confident that this is the best number we can anticipate based on incomplete data.
And we shall hope for the best.
That's right. All right. So Brian, take that one.
So from Kalyani Kamal, is there any chance to reach filing date for a priority date May 2015? So the furthest final action dates for filing made it was January 2015. Final action dates made it to December 2014. That's tough. Any chance? Yeah, that wouldn't really blow my brain open. I wouldn't be hyper surprised if it's sometime maybe late, very late in this fiscal year, they move the dates forward, maybe filing dates forward enough to cover May of 2015.
It's going to be late in the game, and I hope that they all move the dates for filing enough. Now, I can see a date for filing May 2015 reasonably comfortably. Because they need to create a bandwidth to approve cases.
Yeah, with the understanding that maybe it wouldn't be approved during the upcoming fiscal year 2023, but maybe it would be approved.
Then we don't know.
Yeah,
it depends on the rest of the world numbers at the end of the year.
Yeah.
So possible, yes. All right. So, Mr. Malakar.
Yes.
If I receive, so there's an if, did not receive a green card. If I receive a green card EB2 June 2015 after applying for F1 change of status for my child, but before F1 is approved, will she still cover in green card, or she will be out for my green card soon as I apply for F1 change of status for her? All right, so an excellent question. There's a lot of things going on here that I think you may have asked us a question about your child. So if you have a green card pending, also be aware they may give her a hard time to change of status to F1.
She cannot have having a green card pending, though, because his priority date is June 5th, 2015. It hasn't made it that far.
I see. So the question is, should he apply? So that may allow us to revise our answer. Maybe it's better to put her on an F1 before we file the adjustment.
Yeah, that's a good point. If your priority date is going to be imminently current. So let's explain this issue. So oil and water, student status, and intending to get a green card, applying for a green card. Basically, F1 status does not allow immigrant intent, seeking a green card. Meaning, if you have a pending green card and then you file an application to change to F1 status, USCIS should not approve it.
Yes. Now, having said that, if you are on F1, if your child is on F1 already, and she's attending school here, and you file for an adjustment status for her as derivative to yours, it's been historically honored, the F1 is honored for her to continue and will never be challenged unless she leaves the country and re-enter, in which case she has to go back to the embassy to get a stamp. And then the embassy or the consulate may have an issue.
Oh, they'll say
reissuing the F1.
Oh, I understand that you have a pending adjustment of status. Yes, and they'll say, well, gee, your F1 visa you're seeking doesn't allow for that, and
So that's a concern. I've had a recent case last year where the person left the country and then contacted us, and I said, oh my goodness, I mean, they're not going to get an F1 visa stamp. You have pending adjustment status. So we put in a very nice presentation about his college achievements, his grades, and his intention to return home if his adjustment is not approved. And the consulate honored that and issued the F1. But that's what I would say, you got lucky. Of course, he was a good student. He had excellent grades, and he went to a great school. So it all looked good for him, and the consulate felt that this guy deserves to continue to study.
I mean, that's one thing I also definitely agree.
The
consulate
human
has
side.
big discretion,
The human side of it won over the law side of it. But for Malakar, I think you should consider switching to an F1 before you file your adjustment. And I also think you should consult with an attorney on the specifics of your case, so the timing is good for you, and your daughter.
I mean, there's all sorts of things running around here. There's CSPA stuff. There's the ability to change to F1 status with a pending green card. There's a lot of things.
A lot of good stuff in there. Yes, absolutely. All right, wonderful. So Malakar, I am an EB2 prior date 2015. What is the possibility the filing date could be current for me in fiscal year 2023? So we think that. I personally think that filing date should be available for you this year.
I think it's possible to get there.
Filing date, but obviously we all got shell-shocked because of what happened to the visa bulletin in October, but we're hopeful that things will move in the right direction. Brian.
Soj Venkat D. I-45 file moved to the NBC dated 9/10/2022. My priority date, August 2014, and not current with October visa bulletin. What does it mean? Also, I got biometrics notice for my 10-year-old kid. I hear kids below 14 let me see if there's anything more here, I don't think there is at the moment. But yeah, kids under 14 typically don't get Actually, I have heard otherwise on that. Kids under 14 definitely getting biometrics notices. I have heard of them, giving biometrics to a toddler. So,
All right, so we're coming to the 7 o'clock hour. We're going to take one more question, and then we're going to call it a day.
I gotta answer the first half of that question.
Sorry.
Put it back up
Yeah.
there. So what does it mean that my 485 moved to the NBC on 9/10/2022, and my party date August 2014, not current? It means they're trying to put cases in front of people who they can approve them. This is the optimist in me, Sam. The government moves cases when they, when they are current, but they start doing things, before they think they can approve them.
Correct.
Historically, in less strange times, when somebody's priority date would become current in the next month or two, we would start getting RFEs on their I-485 saying, one pending I-485 saying we need X and Y and Z. So.
Yes. So moving on, are we done?
I'd say we take one last
Ajay Shah.
question.
We put him on the screen. We must take care of him.
Yeah.
Thanks to both of you. Well, we really appreciate your help with our community of immigration. We have been in pain for many years. Ajay, you're very welcome. It's our honor to be in a position to help. And it's been very rough for you guys and for us because we really feel your pain. And hopefully Visa Bulletin can move forward.
We talk to people every day who are feeling this. We play attorney, but sometimes we play psychologist, basically helping people deal with the unfortunate facts. Yeah.
Yes. With that, you guys have a wonderful rest of the day, and come back Monday at 6 o'clock Eastern Time to carry on one more hour.